Right.
I think Miss Addy has a statement to hand up, which I've suggested that we would just get out of the way first.
All right.
I'm grateful, my lords. It is simply to confirm what I said on instructions yesterday.
Right.
I gave an answer to your lordship's question on instructions, and because it was on instructions, I said I would undertake to provide a witness statement.
Well, that's entirely
confirming
proper,
that.
but does the statement also explain why this evidence was never given before?
Well, my lords, it doesn't, because I was conscious, obviously conscious of straying beyond the territory of what had happened during the course of my submissions. As a matter of professional conduct, it's proper for me to have those instructions confirmed in writing, and that's what we've done. We have not sought to take advantage of what might be thought of an opportunity to provide further information. It's really a matter of professional conduct as to why that statement has been produced.
All right, thank you. Mr. Pratt.
So, my lords, following on from what I took your lordships through yesterday, I'm going to take the ground somewhat out of order and begin with ground 4, which relates to ostensible authority, not least because a lot of the evidence you saw yesterday elucidates that ground. I took you yesterday to JNFX's denial of ostensible authority, and just briefly, so you've seen our plea in this regard, which is succinct. It's in the core bundle under tab 9, and it's page 199. You see our essential plea drawing on the matters that precede it at paragraph 22, and in particular sub 22.1a and b really summarise our position. And we say, given the evidence that your lordships have seen, there's no scope at all to criticise the Deputy Judge's finding on this issue. If we turn up the judgment under tab 5 of the core bundle, we look at page 173. We see he deals with it there. I'm not going to take you to the authorities bundle, but we place reliance on Freeman and Lockyer, which you see cited at paragraph 30, and in particular, if one looks in the second subparagraph where it says the representation in its commonest form is representation by conduct, that is by permitting the agent to act in some way in the conduct of the principal's business with other persons. And you've seen our plea and you've seen the evidence, which is all to the effect that there was such permission, or it was given on multiple occasions in ample terms, essentially. So no criticism is made of the Deputy Judge for directing himself incorrectly as to this aspect of the law. And then we see his essential findings at 34, 35 and 36. And just looking at 34, you see the first sentence where he held that the evidence was overwhelming to the effect that Mr. Mervyn acted with ostensible authority in respect of the contract. 36, in the second sentence, he dealt with the pleaded allegation that JNFX was unaware of the way in which Mr. Mervyn introduced himself and said it was untenable. Well, it was, and it is, in light of the evidence which your lordships have seen. And realistically, JNFX's pleas, which I showed you yesterday, were ones that should never have been made, not least given the fact that we'd given them all the contradictory evidence way back in October 2022. And I'm just going to chalk off as quickly as I can some of the sub-grounds on this ground of appeal. And if you'll please turn up the grounds of appeal, it's in the core bundle, page 18, under tab 1, hopefully. And so just dealing at the top of the page with subs 1 to 3, there's this armour gas point that ostensible general authority can't arise where somebody knows that the agent's authority is limited in some fashion. To be fair to my learned friend, I don't think she made any submissions on that particular limb yesterday, and she did so with good basis, because there's no evidence whatsoever.
That's right, she certainly took us to armour gas.
She relied on the footer to the email.
I'm going to, okay, well, because that's dealt with under sub 3, I was going to deal with this in that order. So if I'm wrong on that, I take that back. But in any event, I don't recall any express exposition of a case to the effect that there was some express limitation on Mr. Mervyn's authority as conveyed to Mr. Giwa, because there wasn't any. And the evidence that I took your lordships through showed that abundantly, and in fact that evidence went a good deal further. It made clear that Mr. Mervyn had free rein to agree and execute currency exchange transactions from Naira into dollars in the name of JNFX, and it was clear that he was doing so with the full knowledge and outward blessing both of JNFX's directors and its compliance department. And as we saw yesterday, particularly in relation to contracts 9 and 10, JNFX not only permitted him to so act, its directors participated with Mr. Mervyn in forming those contracts. And the judgment, if one flips back to it under tab 5, page 174, paragraph 35, expressly alights upon those same facts. Unquestionably correctly in my submission. Turning back to page 18 and moving on to the reliance on Supreme Court decision of Phillip and Barclays Bank, where effectively third parties under a duty to make reasonable inquiries if the circumstances suggest that there may be a doubt as to the agent's authority. Well, there was never any doubt in Mr. Giwa's mind as to the scope of Mr. Mervyn's authority to act for JNFX in agreeing Naira-dollar exchange transactions. It was perfectly clear throughout that JNFX's directors approved of him acting in that way. They not only watched on as he did so, but as before, they performed their own roles in agreeing some of the transactions he was putting together. We saw yesterday, we don't need to go back to it, Mr. Elam's first witness statement. It's paragraph 30.6, page 282 of the supplementary bundle, where the suggestion was made it was surprising that Mr. Mervyn hadn't made inquiries of the directors of JNFX to ascertain Mr. Mervyn's authority. But we saw that in fact, in substance, he could have done no more than he did in terms of getting the sanction of the directors as to the scope of Mr. Mervyn's authority. He didn't proactively do it by way of an inquiry in the Phillips sense, but the effect is exactly the same. It's difficult to see what better inquiry somebody could make into the scope of a company's agent's authority than exploring that matter with its directors. And on top of that, and of course that's the very inquiry that JNFX said Mr. Mervyn should have been making in Mr. Elam's statement. So really, they could go nowhere with that point. There's the broader point that multiple transactions arranged by Mr. Mervyn were indeed honoured by JNFX, and we can see in the supplementary bundle briefly in volume 1, if we go to tab 6A, Mr. Giwa's affidavit, page 153. And And you see in paragraph 32 here, just by the lower hole punch, JNFX alone paid circa 18.4 million US dollars to MultiChoice Africa's Standard Chartered bank account. So that's in a JNFX account's name, coming from that to the Standard Chartered account. And in total, one sees at page 165, paragraph 68, at the end of September 2021, the total amount was $44 odd million. So the majority of the contracts were performed to the tune of nearly 50% from accounts that were indubitably JNFX accounts. The remainder, whilst they came from other entities, this was evidence that was shown to the Deputy Judge, but I'm afraid it's not before you, largely came attached with a payment reference referring to JNFX. So there was...
When you said the majority, did you say the majority came from JNFX accounts? The total seems to be 44 million, and JNFX seems to have paid...
I meant to say nearly 50%. If I said the majority, I withdraw that immediately.
Yes.
Even if, admittedly, maths has never been my strong point, that's overstating it, if that's what I said. So...
but you said the other payments from others came with JNFX references.
Yeah, so when you'd see it on the
Did you have
MultiChoice...
an example in the material before us?
No, annoyingly, this hasn't found its way in.
Okay.
But I reviewed the transcript, and in fact my notes that I deployed below yesterday, and there were multiple references, for example, from, I think they're called yellow, sorry, forgive my forgetting, but from the various of the other entities that were not JNFX accounts. When the payment came in, it nonetheless had a reference number or signifier that had the letters JNFX in it. I'm not saying all of them, but a good number of them. So there was realistically, in circumstances where Mr. Mervyn was being held out as he was by JNFX as a whole, and where multiple transactions were being honoured in the way that Mr. Giwa thought they were being conducted, as held out by JNFX, there was no reason why he was put on further inquiry as to the scope of Mr. Mervyn's authority. And realistically, moving back to sub 3 of this ground, page 18 of the core bundle, which is the footer point, all of the same points apply. The significance of the footer, as explained by my learned friend yesterday, was not to say that it operates as some kind of contractual exclusion clause, but instead was said to put its recipient on inquiry as to whether or not the sender had the necessary authority. So the same answer is really, as to the Phillips and Barclays Bank subground, applies here. Small print on emails, which nobody reads, cannot on any realistic basis trump the sanctioning of Mr. Mervyn's conduct by JNFX's directors and its compliance department. And we look at these points as addressed in the judgment, back under tab 5, page 175. He dismissed them at paragraphs 37 and 38. He might have done so in more fulsome terms than he did, but in my submission, given how hopeless these points were and are, his rather summary treatment of them is somewhat understandable, And in any event, this isn't a lack of reasons appeal.
Attention please. Attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers.
We will resume when we can.
Attention please. Attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now